International law. Let's take a look at international law and try to understand a little bit more. Now, I'm Desiree Dubonnet, and I've been an international lawyer in regulatory affairs for many, many years, and I'm here to basically tell you a little bit more. Because copyright law is basically something that's an obvious example of international law, and that the need for evidence is very important if you're going to be doing something with international claims. Let's learn a little bit more about international law and how it applies to our international medical university.
Subjects of international law are entities in possession of legal personality. They enjoy rights and hold responsibilities towards the international community. International law replaced the medieval order of Europe by creating legal relations between entities claiming to be sovereign, equal and independent. As international personality is an inherent feature to statehood, states are the traditional and primary subjects of international law. However, there are other players, like international organizations.
The International Medical University of Natural Education is an example, just as
multinational corporations, non-governmental organizations, and the individual. While they are objects of international law, yet enjoy a degree of international legal personality because states allow them to do so. International organizations are created by states. They are partial subjects, with limited rights and duties, as their legal personality depend on states' actions.
IMUNE started as a Swiss charter that was started by Carl Jung, and we bought from his daughter Gret. And then we decided later that it would be better for us to move to the British Virgin Islands, which would give us more freedom in creating different types of license. So we started it and then basically reorganized it recently in the British Virgin Islands to be able to do this work. So we were able to take IMUNE and organize it as an international medical university that would be started with one of the states and thereby could work in an international community to be able to supply medical education to the people of the world.
On the other side, non-governmental organization is established by individuals under domestic law, but despite the global reach and impact, it's not a subject of international law. While multinational corporations have extensive global power, sometimes even more than states, the development in investment law helped them to acquire a partial legal personality. In particular, as states and multinational companies are considered equal parties to a dispute before the courts. While international law is mostly made for states, the individual today is qualified as a partial subject of international law, in particular in the area of war atrocities, genocide, and crimes against humanity, seeing that these actions are committed by persons, and not by abstract entities. And lastly, when rebels or belligerents gain de facto control of a certain territory, they may enter into international agreement, which makes them a partial subject of international law.
With a host of different instructors who have backed us and basically given us the ideas of the foundation of the belief of IMUNE, we're able to structure an international medical university operating under international law, being able to give out diplomas and doctorates and many other things, and in licenses, so that under international law we could protect natural medicine and make sure that natural medicine was so protected that there would be licenses behind it, and we could protect natural medicine. And if you would like to donate, please advise and look below, and you'll be able to see ways to donate. Let's look more about international law.
Advanced legal research class in international law and specifically dealing with United States treaties. One of the first questions that a legal researcher might be interested in this area is just exactly what is international law. And many times international law is frequently confused with foreign law. That is the law of a foreign jurisdiction like the United Kingdom or Canada. International law can generally be divided into two categories. First one is private international law, which focuses on individuals from more than one country, usually involved in a business or commerce situation. And the more important aspect of international law, which is public international law, which is the law reflecting the custom and practice of sovereign states as they deal with each other and with individuals. There are some very important aspects of international law for American lawyers. First, treaties, agreements, conventions are the most important primary source of international law. There are self-executing treaties and agreements which go into force immediately. And there are also non-self-executing treaties and agreements which may need subsequent implementing legislation. It's also important to keep in mind that judicial decisions from national or international courts are considered to be evidence of international law. And finally, customary law is also an important source for international law, and that area primarily deals with state actions. That is, looking for a state acting in accordance with the principles of international law. Some other important aspects of international law for American attorneys is that United States federal courts define, interpret, and apply treaties and principles of international law on an almost daily basis. That's federal courts from the lowest courts, the trial courts like the district court, all the way to the United States Supreme Court. There are also some major practice areas that involve international law. And those areas are areas such as tax, both tax administration as well as tax policy, intellectual property, labor law, commercial law in general, as well as criminal law, which could focus on an area such as extradition. One of the important components that you need to understand is a definition of what a treaty or an international agreement is. The Vienna Convention on the Law of Treaties is an important source for a definition. And the Vienna Convention describes a treaty, first of all, as an international agreement that has to be concluded between and among states or international organizations. Treaties, conventions, international agreements have to be in written form. There cannot be an oral agreement between or among states. Also, treaties or international agreements have to be governed by the principles of international law. And regardless of a designation, a treaty can be called an agreement, a convention, or a covenant, regardless of what language is used to describe it. If a document meets the requirements of the Vienna Convention, it really doesn't matter what you call it, whether you call it a treaty, an agreement, a convention, or a covenant. There are some important resources that you can use to get aspects of international law, and particularly treaty law, available to you. The Boston College Law Library website has a component under its research international area for treaties, which gives you links to sources like the United Nations Treaty Collection, treaties on Thomas, which will be discussed later, as well as the United States State Department's legal advisor for treaty affairs. These are all databases which are available for you to use, and you can find them linked right off of the BC Law Library website. Another important area that you could take a look at would be the United Nations Treaty Collection, which is sponsored by the United Nations. This is a place where you would go to find treaties where the United States was a party to the treaty, as well as treaties where the United States was not a party. Most of these treaties will go back to 1945, which is the beginning of the United Nations, but there is also available through this link another earlier series called the League of Nations Treaty Series. And finally, the American Society of International Law has this EISIL, or Electronic Information System for International Law. This is a very important tool because it categorizes international law by broad areas and allows you to get access to historical materials, to treaty collections, and to other materials that can be very useful in determining what is the basic international treaty law for a particular
Let's
area
look
of law.
at the history of international law so we could understand
came out of them, how they developed, etc. But I'd like to take a look specifically at a very interesting little clip in which some of the cast of characters are, well, they're interesting in terms of their relations and what this says about where this idea for an international court actually comes from.
Morgenthau was opposed in the United States by Secretary of War Henry L. Stimson. Stimson believed that the German war criminals should be dealt with only by trial before an international military tribunal. Stimson's view was that to punish these men after a trial would stand better in history. Moreover, that this process would develop a record of Nazi criminality which would stand in history. Stimson's views ultimately prevailed in the United States.
The laws of God and of man have been violated, and the guilty must not go unpunished.
On May 8, 1945, President Truman appointed Supreme Court Justice Robert H. Jackson as the United States Chief of Counsel with the mission of bringing together the four major powers in developing an agreement for the trial of the major German war criminals.
He also said that this must be a real trial, not a show trial, not a Stalin trial, but a trial which could result in acquitting a defendant if the evidence did not show guilt.
There were hundreds of thousands of foot soldiers, let's say, of Nazism, who carried out the mass executions, operated the gas chambers, shot the hostages, and so on. But what about the top leaders? How did you convict them? None of them shot the bank guard, blew the safe, or drove the getaway car. Their hands were clean. There existed no international court. There existed at the time they were preparing for the trial no body of law. There existed no judges. There existed no courthouse. The instruments for trying a drunk driver in any part of the United States were more complete than the instruments for trying mass murderers in Europe at the end of World War II. So they started from scratch. A lawyer in the War Department by the name of Murray Bernays was given the task of devising some kind of philosophy for this trial. Bernays came up with a brilliant idea, which was the conspiracy theory, that the whole Nazi movement was just not simply a legitimate political movement, but it was a criminal conspiracy designed to seize the territory of Germany's neighbors, to steal from these nations their wealth and their people, and to exterminate their Jews. And this conspiracy theory meant that by being a part of the Nazi leadership, you were part of a criminal conspiracy, and it was a net that held these people.
It was agreed that three major types of crimes would be charged against these individuals. The first was the crime of waging aggressive war. The second was ordinary war crimes. And the third, crimes against humanity committed in the course of the war.
Oh yes, Nuremberg was a victory for justice, and it helped establish the new paradigm of an international rule of law, so that never again could a nation ever commit an act of aggressive war and not have its leaders prosecuted for that act of aggression, right?
Well, in actual fact, the man who organized and designed the Nuremberg trial was then guilty of probably the most horrendous war crimes of all history, in the atomic bombing of women and children on non-military targets without warning. In Hiroshima and Nagasaki, a second bomb, the only person who's ever dropped atomic weapons on human beings. And under international law, I was one of the few people who had the guts and the balls to be able to make an international war crimes trial. And filming that movie, which you can watch on YouTube, in 2008. And then later, that movie was given a top accolade award at the La Jolla Film Festival. And somebody wrote, who could have the courage to do this? You see, in America, in certain places, like in Colorado, they tried to forget and tried to erase history and tried to get history to forget about Nagasaki, Hiroshima. It's incredible. So international law started and was starting to help people. And then George Bush Sr. had some ideas.
A new partnership of nations has begun, and we stand today at a unique and extraordinary moment. The crisis in the Persian Gulf, as grave as it is, also offers a rare opportunity to move toward an historic period of cooperation. Out of these troubled times, our fifth objective, a new world order, can emerge, a new era, freer from the threat of terror, stronger in the pursuit of justice, and more secure in the quest for peace. An era in which the nations of the world, East and West, North and South, can prosper and live in harmony. 100 generations have searched for this elusive path to peace, while 1,000 wars raged across the span of human endeavor. And today that new world is struggling to be born. A world quite different from the one we've known. A world where the rule of law supplants the rule of the jungle. A world in which nations recognize the shared responsibility for freedom and justice. A world where the strong respect the rights of the weak. This is the vision that I shared with President Gorbachev in Helsinki. He and other leaders from Europe, the Gulf, and around the world understand that how we manage this crisis today could shape the future for generations to come.
So international law does exist. It has its problems. It has its boundaries. It's been designed to assist people in marketing and moving different material. It has also been used to help punish people who are doing international crimes. So here at the International Medical University, we were able to make a true medical university to protect natural medicine and be able to be above the reaches of any one country or the evil corporations that could try to destroy our work at preserving natural medicine. We offer you an education. We offer you a license. We offer you an ability to practice under international law. And then we can adapt that and apply in your locality, in your country, to get you and your education work, and to get you accreditation in your country to be able to work and practice natural medicine.